I'd like to waive 20 minutes to Mr. Gelber.
Representative Frankel, I would appreciate while you are recognizing your members if you'll point to them and make them stand up and wave their hand. Representative Gelber, welcome to the House, and you are recognized for 20 minutes.
May I approach the well, Mr. Speaker?
You're given permission to approach the well. While Representative Gelber does that, for people that aren't familiar, the Florida House of Representatives just underwent our first term limits, and we have 63 freshmen, and we're very excited about working with them. Representative Gelber, you're recognized.
Thank you, Mr. Speaker, and thank you for affording me the privilege to speak from the well. Members, I speak today in support of the amendment, and if the Speaker's comments would remind me that I'm a freshman, it's pretty obvious he doesn't even know who I am. Most of you don't know who I am. We don't know who each other are, and here we are making one of the most important votes I think any legislature anywhere is ever going to make. But the irony of this moment should not be lost on anybody in this chamber, especially the citizens of our state. In the same breath that we are told that this session is about preserving the votes of Floridians, by the majority resolution today, we will be disenfranchising every single voter who went to the polls on November 7th. While we are told that this session is about respecting the rules, the majority's resolution will declare irrelevant all of the rules that this legislature has created to govern and resolve elections. While we are told that we must act to protect our electors, I believe if you look at the United States Code and read it, you will see that this action does nothing but jeopardize our electors. And perhaps most ironic is we are about to insert ourselves into a process and declare ourselves the paramount authority when the United States Supreme Court, as many of my colleagues on the Republican side have said, are about to consider the exact same issues. And I wonder, just like my fine colleague from Tallahassee, why we are here today. We are here, as the majority have said, because of the oaths that were taken when we assumed our office. Well, we in the minority took exactly the same oath that you did. And for me, it was not my first oath. In fact, I swore to uphold the Constitution as an assistant U.S. attorney, as a chief counsel in the United States Senate. And each time I took that oath, it was very interesting. I never, ever took an oath of fidelity to a particular party or to any particular candidate. Rather, each time that I took that oath, just like every public officer who takes that oath, I took an oath of allegiance to the Constitution, to a set of rules, to the wonderful notion that respect for the paramount authority of law is what separates us from nations where the absence of such law is a constant and daily threat to freedom. It has been said that we are a nation of laws. It will be said throughout this debate, I am sure. But the matter before us today will test the truth of that statement and its continued vitality in this chamber. And I urge all of you, even though I am a freshman, we need to look at this very carefully. And to my fellow freshmen, we need to know what we are doing here, because what we are about to do and where we are about to embark will be a very, very terrible precedent for legislatures to come. Now, the legal reason we are told we have been here by the folks that spoke before me is our fear that our inaction will leave Florida's electors at sea. I submit to you that if you look at the law in this regard, you will see that this proposition is wrong. And further, those same laws assure us that the singularly most perilous course we can take in this chamber is the course that is being offered through the majority's resolution, because it robs the people of their right to have their votes counted. And while we can talk all we want about our preserving the rights of votes, when we vote today, and if the majority votes and they win, the people of America who showed up in Florida to vote for their president will have wasted their trip to the polls. And that is the truth, and we'll be giving that decision to this chamber. I urge my colleagues to consider the minority amendment. Let me first address the majority's argument that this body is compelled to act because of Section 2 of Title III of the United States Code. Read that provision very carefully, because it doesn't exactly comport with this notion of plenary and absolute authority. Whenever any state has held an election for the purpose of choosing electors and has failed to make a choice on the day prescribed by the law, The electors may be appointed on a subsequent day in such a manner as the legislature of such state may direct. This is why we are here according to the majority, this provision of law. The majority's view is that this compels us to act, and the key phrase here, the key phrase in the logic of the majority, is that there has been a failure to make a choice. A failure to make a choice. That is the key. And what do they point to, and what do my colleagues point to show there has been a failure to make a choice? There is a contest of the election. There are all these lawsuits. Everybody's making a big deal. It's a close race. That, under the law, is not failure to make a choice. There has been no case ever. There is nothing in the enabling legislation of that provision. No legislature in the history of our country, at least since this act has been enforced, has ever interpreted an election contest, the mere existence of a contest, to mean we have failed to make a choice. And that is where the majority and minority depart in their analysis. Why has nobody ever advanced such an interpretation? There's a very good reason. Because an interpretation like that would turn the rule on its head. I mean, the purpose of the rule is to say to the legislature, you do have authority to create the manner, but Congress has the authority to tell you the time. And you cannot act. For all this talk about the plenary or absolute power of this body, isn't it sort of interesting that we have this provision that exists here today that tells us we cannot act till that has been found? Why can't we? Think about the problems that will happen if just merely the presence of litigation allows a legislature to hijack an election. A state with a legislative majority whose candidate of choice appears to have lost simply needs somebody, any partisan or just anyone. And in Florida, there's enough lawsuits, we know somebody will file a lawsuit about something. And if the presence of the litigation continues, the legislature will simply be able to disenfranchise itself. Now, during the hearings of the Select Committee that preceded this session, the majority's experts and some of my colleagues from the majority suggested that question whether an election has failed is a factual issue for us to determine. We must look at the facts, we must consider the law, we must make that determination. And then it occurred to me as I was listening, haven't we created a process to do exactly that? Are we supposed to prejudge every single lawsuit that comes to decide whether it is meritorious, and then if it might be meritorious and contest the election, then we must act? Well, why would we do that in the first place? If it is a meritorious lawsuit, wouldn't that suggest that we ought not act? To give ourselves the ability to throw every election in such disarray is to invite a horrible precedent that will be a stain on this chamber. Now, we should note that there has been some discussion about taking out of this resolution the phrase, and it is in the current form, that the Florida legislature finds that the election for electors and vice president has ultimately failed. That's in the majority's resolution as it stands. There's been some talk about taking that out. Listen, for you to act, when you act, you are finding by your vote that this election has failed to make a choice. And you are saying the determination of that is simply the presence of an election contest. The obvious meaning of Section 2, the obvious meaning of failure to make a choice, we don't have to look very far for. It's upstairs in this building. It's in the Department of Elections. We have a code section that creates exactly this process. Go to 103.011. That provision just does two very simple things. First of all, my colleagues are correct. We have the right to create the manner in which our electors are established. That provision is us telling our constituents they have that right. That's what the first part of that does. We gave it to them. But the second thing it does is it tells the Department of State to certify the electors of the candidate who receives the highest number of votes, to declare a winner. And in our case, we had an election on November 7th. Winner was certified exactly as the provision requires. And in fact, Mr. Roberts, who is an employee of Secretary Harris, appeared at our hearing. I was permitted, with leave of the committee, to ask a question of Mr. Roberts. I had one simple question. Who won the election? According to the authority of the state, who is the winner of the election? Mr. Roberts, without pause, and go and ask him right now, will tell you. Governor Bush won the election. He is the winner. He has a certification that he has won. That certification has been sent to the National Archives. It is waiting to be counted. Now, it is possible that that winner may change. But if that happens, Governor Bush, our Governor Bush, will simply send another certification over, replacing the one that exists. The point is, our process has declared a winner. We do not need to decide that we have to declare a winner. Section 2 simply cannot provide a basis for this body to act. But the majority have suggested that Section 2 is not the only authority, and they point to the McPherson opinion and this whole notion, and this is an important notion, that the legislature has a plenary or the sole and unlimited power to do as it seems fit with regard to the selection of electors. This is an important notion, because let's understand something about McPherson. When McPherson occurred, African Americans in this country were counted as 3/5 people. McPherson has to comport, and obviously our actions have to comport with the Constitution. Does anybody in this great chamber think we could decide that only white men who own land can pick electors? Obviously not, because that would violate at least two concepts of our Constitution. So McPherson is not sort of this idea that we can do as we seem fit whenever we want to. In fact, it's much different than that. First, the federal Constitution has only told us we can do the manner. We can decide whether we pick it or whether the people pick it. But it has also told us that we have to comport with the Constitution. And in fact, in the 100 or so years since McPherson, obviously all those things that give people rights have grown up around this concept of plenary power. But once we create that process, we are obliged to follow it. That's the manner we chose. We gave people the right to request recounts, to create grounds for contest, to create a contest phase in the courts, and to give the courts the right to fashion pretty broad remedies. But there's something else you should note about this and why it's pretty obvious we can't do whatever we want to. Look at Section 2 itself again. It is, by its very nature, a conscription on our ability to act. We cannot act until there has been a failure to make a choice. So if everyone stands up and says we can do whatever we want, ask yourself why there's a United States Code provision that says until there's been a failure to make a choice, you must stand down. You know, the scholars that came before us, and there were a lot more lawyers than I wanted to see and a lot more law professors. I had a bad flashback to law school, who came before us. You know, there's something that the 50 that signed that letter said. And they said that if we act right now, we will be turning this rule on its head. We will find that a failure to act, a failure to reach a vote has happened when we shouldn't trigger that yet. And they said that the frolic that the legislature has come will not merely be unwise and irresponsible, but it will be also unlawful. And I think that's something we need to think about, whether we are actually committing an unlawful act by attempting to jump into this fray when we really are not allowed to. Now, let's talk about this safe harbor that has been put up here. And the safe harbor is very important because, first of all, it's not really relevant to our debate here today. The safe harbor is simply the following. Safe harbor is of Section 5. Basically says, in very simple terms, it's a pledge sort of between Congress and the states. If we get our act together by December 12th, if we get our act together and we select a slate by a process that does not change after Election Day, then our slate will be deemed conclusive, so long as our process is complete, and that section talks about contests, so long as there's no contest pending. There is no question the safe harbor is gone. We are out of the harbor, folks. It doesn't exist anymore. First of all, it doesn't exist because there's a contest. And a lot of you may say, well, wait a second, if there's a contest, doesn't that mean that the election hasn't reached a conclusion? According to that other section, Section 2. And the difference is there are two different provisions. Not having reached conclusivity is different from failing to make a choice. Those two provisions were created decades apart and have little to do with each other in this regard. But the key here is that it's a promise that if we stick by the rules, we will be able to actually have a winner that will be viewed conclusively by the Congress. It is no longer relevant. And by the way, our action cannot put us there. Because the one thing that we know about the safe harbor, is that it has to be done by December 12th, and I believe our counterparts are not acting until tomorrow. But we also know that we can't change the rules after the election. And clearly we have rules. It's in the courts are supposed to decide this election, and if we act, it'll be a change in the rules. It'll be something new that obviously was not happening on November 7th when we told people that they should vote to pick their president. So that's not going to happen. Now, the best way to assure that our slate is as conclusive as it can be is to rely on the certification that we have sent up on November 26th, which was certified within our legislative framework. Our action might jeopardize, in fact, that slate. The governor and the Secretary Harris have signed that slate. Now, that may change if the vice president prevails. It's possible we'll have to have Governor Jeb Bush send a new slate up to the archivist. If the Supreme Court allows us to count, and we have a new winner. But in any event, if we do nothing, if we follow the minority's amendment and we do nothing, we will always have only one slate. And one slate is always better than two. You see, if you look at Section 15 of Title III, it tells you the only way when you have one slate, that one slate will not be counted, is if both houses of the federal Congress agree to reject that slate. That's very important. Let me repeat it. The only way to lose your one slate is if both houses agree to reject that slate. And we all know what the current lineup of our House and our Senate is. There's no chance there's going to be agreement to reject the only slate Florida sends up. This clearly will not happen. However, if we throw in our other slate, and this is a second slate, we now have two slates pending before the House and the Senate. Two slates in the mix. Now, go to Section 15. And according to Section 15, when there are two slates pending, the Houses of Congress must agree on which one they prefer. So the same difficulty you have in rejecting our slate when there's only one, you have in agreeing on a slate for number two. Now, that might not be a problem if all the slates are for Governor Bush, but we are here because we want the process to be fair. And if the Supreme Court turns around the election and the votes count the other way, as the Democrats are hoping, we will have two slates of different parties, and we will have created a serious constitutional problem. Professor Ackerman said he did not want to even think about it. I'm sure he does want to think about it because that's what apparently he likes to do, but this is a real problem, and we will have created it because we will have created less conclusivity in this process by our very action. Now, let me finally speak to the actions and the rulings of the Florida and the United States Supreme Court, and I agree with Representative Alexander. I am not sure why we are here. Look, it is ironic that the majority is relying so greatly on the Supreme Court's opinions in this matter. And the points that were raised, it was raised by the Supreme Court. But remember what the High Court said to the Florida Supreme Court. Think about it. Basically said when they extended that Katherine Harris 7-day deadline, Supreme Court said to the Florida Supreme Court, you know, we're not sure whether you did that based on a statutory interpretation or whether you did that based upon some frolic of the state constitution. We don't know what exactly you did. If you did it as a statutory interpretation, it's probably okay. But if you did it otherwise, it might endanger the safe harbor, some other problems. Well, the safe harbor was, when it made that opinion, the safe harbor was still a possibility. It's not anymore. But the point is, the U.S. Supreme Court was saying, you could have done it right. It's possible you did it wrong. But what should be important, and the lesson here, is that all of the concerns that have been raised, and they all have been constitutional concerns for the most part, all of the concerns that have been raised apparently are being reviewed by the United States Supreme Court. They are there right now. They are writing an opinion that is going to shed light for all of us. So I am unsure as to why we are here. We are about to change a process that we created while literally just hijacking the entire process and saying everything that's going on in the courts we don't care about. We have the plenary authority to do as we seem fit, when the actual High Court of the land is making that decision right now. Now, I may not agree with what the U.S. Supreme Court does, or I may, I don't know. But it won't matter what any of us, how much we agree or disagree. Because at the end of the day, they are, and no one disputes this, the highest authority in our land. And I wonder why this body believes that we should render an opinion now, when the exact same issues that have been attached for our debate are also being debated by the U.S. Supreme Court, and they will resolve. I don't think anyone here thinks we are better suited or better able to navigate these legal waters. And I believe that this act really reflects an act that is not befitting of the People's House. I don't think that throwing ourselves into this mix at this way is appropriate. Ultimately, today's impending action, I believe, is an assault on the rule of law, and we've heard about that. But in supporting this extraordinary action, the Republican majority is saying that they do not want the election process to go forward pursuant to the laws that we created. They do not want the courts to consider the appeals. They do not want the established process to run its course. The Republican majority's resolution is bad government in its worst. I urge you to support the Democratic amendment.